to you in your presentation, sir. Go
Thank
ahead.
you. Thank you. And good evening, Mr. Chair and Senators. Thank you for inviting the All Party Parliamentary Group to end modern day slavery and human trafficking to appear before you on Bill C-75. Our group launched in 2018, and I know that many of you are members of it, and we have 4 co-chairs representing the three parties in the House of Commons and the Independent Senate group represented in Senator Christmas. I apologize that, or on behalf of MP Moore and MP Ouellette, that they were unable to attend here today. Human trafficking is a horrific and brutal crime that's growing in Canada and all around the world, and it's often described as a form of modern slavery. Human trafficking is probably happening within 10 blocks of where you live. We know the vast majority of human victims in Canada are female and young, and while those most at risk include Indigenous women and youth, teenage runaways, and children who are in protection, we know that anybody can become a victim of human trafficking. The All Party Group has reviewed the amendments proposed by C-75 around human trafficking and has serious concerns about the consequences of such amendments that they will have on the successfully addressing human trafficking in Canada. Specifically, Bill C-75 proposes to hybridize Section 279.02 Sub 1, the material benefit from trafficking, Section 286.2 Sub 1, material benefit from sexual services, and Section 279.03 Sub 1, withholding or destroying documents for the purposes of human trafficking, which are currently indictable offenses. If the amendments to hybridize these 3 offenses in Bill C-75 are accepted, a trafficker found guilty of these offenses could end up with a fine for $5,000 and face no jail time. The deterrence provided by a $5,000 fine is minimal compared to the $300,000 a trafficker can make for only one victim in a year. In considering the extreme violence and degradation and torture that these victims of human trafficking often endure, the punishment proposed for the offenses clearly does not correlate to the nature of the crime. Bill C-75 would also finally bring into force the previous Bill C-452, which was proposed by former NDP Member of Parliament Maria Morani. This bill contained 3 important tools to fight human trafficking: a reverse burden of proof in cases of human trafficking, the ability for courts to seize the proceeds of crime for human trafficking offenses, and consecutive sentencing for human trafficking offenses. The All Party Group notes with regret that the significant delay in coming into force of Bill C-452, which was adopted in the House of Commons unanimously in 2013 and adopted by the Senate in 2015. Regrettably, law enforcement and prosecutors have waited 6 years to use these tools. The reverse burden of proof on traffickers and the seizure of proceeds of human trafficking are critical to diminish human trafficking. We support this long overdue section and coming into force with these amendments. Consecutive sentencing. Human traffickers often exploit more than one individual at the same time, and may often be charged with multiple human trafficking offenses for multiple victims. While the elimination of consecutive sentencing would mean that an individual found trafficking several victims would end up only having to serve the imprisonment for one of the offenses. The loss of consecutive sentencing will also be a contributing factor to victims' continued reluctance to come forward and report a crime due to the immense fear and psychological control that their traffickers have over them. Victims will recognize that the result of their reporting, which puts them at a high risk of real harm from their perpetrators, will serve no real purpose. The result of this proposed amendment is startling. It erases victims and will do little to deter their traffickers. I'll now turn it over to Senator Christmas.
Thank you, Mr. Vierson. Good evening, fellow senators. Judicial discretion in Indigenous victims. Indigenous women are the highest represented victim group in human trafficking in Canada. They only make up 4% of the population of Canada, but make up at least 50% of the victims of human trafficking. Due to systemic discrimination within policing and judicial systems, Indigenous victims of human trafficking often do not report their crimes. Further, a special Senate report considering Indigenous women as victims of crime found that their offenders often receive lesser sentences than if the victim was a non-Indigenous female. Such factors demonstrate that the proposed amendments in C-75 to provide discretionary prosecution of hybrid offenses will significantly increase the likelihood that a human trafficking offense against an Indigenous woman would likely proceed as a summary conviction offense, further denying them justice. Conclusion. Human trafficking in Canada is a criminal activity that is elusive, complex, and underreported by its victims. It's low-risk, high-profit crime that can provide traffickers with a significant amount of profit and little chance of being caught. The proposed amendments to human trafficking offenses in C-75 would provide for minimal punishment and deterrence to offenders who are found guilty of such offenses. Considering that traffickers are currently at low risk of being charged and prosecuted, such amendments further hinder any real efforts at addressing this growing societal problem. It's a fact that Indigenous women are also overrepresented in the human trafficking industry. Coupled with systemic racism and judicial discretion, the amendments will specifically contribute to their continued disadvantaged position in the criminal justice system. Thus, the proposed amendments in C-75 around human trafficking offenses will result in justice being increasingly denied for human trafficking victims. We therefore respectfully recommend that Section 279.02 Sub 1, Section 279.03 Sub 1, and Section 286.2 Sub 1 of the Criminal Code not be amended and remain as indictable offenses. We also recommend that the amendments proposed by Bill C-452 be brought into force as originally adopted by Parliament. We thank the committee for giving us this opportunity to be heard, and we are eager to respond to any questions honourable senators may have. Thank you,
Thank you very